move this out the walkway as well for you, so.
Is your mic working? Okay, all right. Yours is good. Y'all have already checked yours. And you don't have a mic, you're just...
Yeah, just
Okay. Okay, all right.
These white down, put your down clear. These white down, put your down.
You ready? Sir, are you ready?
Yes, sir.
Okay, I'm gonna go ahead and bring him in.
Thank you.
Yeah.
Ladies and gentlemen, good morning. My name is Ben David, District Attorney for New Hanover and Pender Counties. I have been asked by the Deputy Director of the Administrative Office of the Courts to handle a matter that I know is very important to the members of Onslow County, and that is the December 27 shooting death of Andrew Clukey. I'm here today to make some statements about that case since we inherited it back on January 10th. We have been working tirelessly on it. I have brought some of my team with me, and they will be prepared to assist you with some of the information I'm going to be providing. My administrative assistant, Samantha Dewey's, has a press packet that I'm going to be distributing immediately following this. Senior Prosecutor Crystal Lawler will be reading some of the investigation in just a moment. And Jeffrey Skip Hedge, DA investigator, has already welcomed you into this room and helped with some of the early logistics. I will be glad to answer any of your questions following a prepared statement that I'm going to be reading along with Ms. Lawler. But let me begin that now. Prosecutors are often charged with analyzing the actions of individuals who, in many instances, wish they could roll back the hands of time to the moments before a serious injury or death occurred. Despite the tragic circumstances of these incidents, our duty as prosecutors is to determine if a crime took place, identify the corresponding law that supports a criminal prosecution, and evaluate the likelihood of conviction of such a charge at trial. These guiding principles have been applied to my assessment of the shooting death of 15-year-old Andrew Clukey by his father, John Clukey. Now, over the last 10 days since being assigned this case, my prosecutors and I have reviewed the complete investigative file of the Onslow County Sheriff's Office and have carefully considered all relevant evidence. At no time has my office solicited or received the opinions of Onslow County District Attorney Ernie Lee, Chief Michael Yanero of the Jacksonville Police Department, Sheriff Hans Miller of the Onslow County Sheriff's Office, or anyone in any of their offices about how this case should be resolved. I have arrived at the legal conclusions set forth in this press conference, relying solely upon the input of my senior assistant DAs, who have over a century of combined experience in prosecuting violent crime, especially homicide, in this region. The officials who I've just mentioned heard about my decisions in this case within the last hour, and I've not talked to them otherwise. It should be noted at the outset that in the more than 17 years that I've been the elected district attorney for New Hanover and Pender counties, my office has always put our children first, and we have taken a very hard line on prosecuting anyone who would do them harm. We have established court precedent and procedures to put our most valuable citizens as our first priority, to make it clear that first, prosecuting violent crime is our top priority. Second, that a pattern of reckless behavior is tantamount to intentional conduct. And third, that parents and caregivers owe a special obligation to the children in their care. It is also true, however, that a prosecutor's role is to do justice, not to convict at all costs. Sometimes justice lies in not pursuing a charge at all, despite the fact that a life has been tragically cut short. Now, the law in North Carolina allows for the possibility of there being such things as accidents leading to death for which no criminal liability attaches and for which no criminal prosecution is appropriate. There have been instances, for instance, where a parent feeds their child food they mistakenly believe to be healthy when in fact the food is tainted with lethal result. There have been instances in which a tenant shoots and kills someone they mistakenly believe to be an intruder threatening their life, when in fact it was just a person like their roommate who was coming in through a window, and that person lost their life when they were just attempting to get their keys. Of course, in either type of case, law enforcement is never satisfied with simply taking the word of the parent or shooter, but must undertake a thorough investigation to see if the totality of the evidence, including surrounding circumstances and past history, indicate beyond a reasonable doubt that what has happened is something other than an accident. Still, the principle remains that unless the state can disprove an accidental killing, there is no crime that can be charged. Now, we have detailed a summary of this Onslow County Sheriff's Office investigation. Again, this will be handed out to you as well. I'm going to call on this time Crystal Lawler from my office to read that summary aloud to you, and then I'm going to summarize the legal conclusions that we draw from this investigation. Krista.
On December 27, 2021, Jacksonville Police Department Detective John Clukey left his home in Beulahville, North Carolina to retrieve his department-issued vehicle from the Jacksonville Police Department. As is department policy, Clukey was wearing his department-issued firearm, a Glock handgun in a holster on his side, because he was going to be driving his vehicle. Clukey was dressed in civilian clothing. When he returned home, Clukey was greeted by his 15-year-old son, Alexander, in the front yard. Alexander had 3 airsoft guns, which were Christmas gifts, and asked his dad to play with him. Clukey took 2 of the airsoft guns. Both were pistol style. Alexander armed himself with an AR-15 style airsoft. Clukey placed one pistol in the waistband of his pants and armed himself with the other airsoft pistol. Clukey also armed himself with a shield, a discarded DirecTV satellite dish. Clukey and Alexander engaged in an airsoft battle in the yard to the side of the residence. This side yard is outside the view of the Clukey residence doorbell camera, and there were no neighbors outside at this time. When the pistol in his hand was emptied, Clukey discarded it. Clukey reached for the pistol in his pants waistband. However, instead of grabbing the airsoft pistol, he grabbed his duty weapon, which was still holstered on his waist. Clukey discharged 1 round from his duty weapon. Consistent with the loose grip that he would have been using with an airsoft gun and not a real firearm, the Glock malfunctioned, causing a stovepipe that prevented the shell casing from fully ejecting from the Glock. The jammed Glock caught Clukey's attention, and only then did he realize that he had fired the Glock and not the airsoft gun. The round struck his son. Upon seeing Alexander injured, Clukey ran to his son and called 911. An Onslow County 911 dispatcher asked Clukey the address of the emergency, which Clukey provided and said, "My son was playing fake guns and someone shot with a real gun." Clukey remained on the phone with the 911 dispatcher for over 11 minutes, awaiting the arrival of emergency personnel. The 911 dispatcher asked Clukey to ensure Alexander was flat on his back, but Clukey replied that he was not able to turn Alexander from his side onto his back because he was bleeding from the nose and mouth. Clukey reported that Alexander was turning purple. Alexander was heard on the 911 call breathing. The 911 dispatcher asked Clukey where Alexander was shot, and he replied that it happened that he was shot in the head. The 911 dispatcher asked Clukey to apply pressure to the wound. As Clukey applied pressure to the wound, Alexander's breathing became more labored, and he could be heard moaning on the call. Clukey made efforts to calm Alexander, apologizing to him and asking him to remain still. On several occasions throughout the call, Clukey made several statements expressing remorse, such as, "I deserve everything I have coming to me. Take me instead. Stay with me. And I'm so sorry." At one point during the call, one of the other Clukey children exited the residence, at which point Clukey told the child to go back inside the house. Later in the call, other adults are heard on scene bringing towels to help tend to the wound. The 911 call concluded after 11 minutes when emergency personnel arrived on scene. Clukey told a neighbor who had shown up to assist that he shot his son, mistaking the Glock for the airsoft gun. Emergency responders transported Alexander to Naval Medical Center in Jacksonville. Due to the extent of his injuries, Alexander was later transported to Vidant Medical Center in Greenville. The Clukey residence is in Onslow County, and the Onslow County Sheriff's Office conducted the investigation into this incident. The Onslow County Sheriff's Office detectives were unable to identify any eyewitnesses to this incident, and it was outside the view of any cameras on houses in the area. One neighbor reported hearing a gunshot, but did not view the incident. Onslow County Department of Social Services employees interviewed the other Clukey children, who reported no previous maltreatment of or ill will towards Alexander. Detectives inquired with officials at Alexander's school about any maltreatment or ill will and found that the Clukeys was a loving home and that there was no animosity on the part of John Clukey towards Alexander. Every member of the Onslow County Sheriff's Office who came into contact with Clukey reported no signs of impairment. Clukey denied any drug use or alcohol use. This was corroborated by his wife, Wendy, who was separately interviewed by detectives and DSS investigators. Clukey was cooperative with the investigation of this incident from the start, submitting to detectives' questions and separate questioning by DSS investigators. Alexander remained at Vidant Medical Center through January 3rd, 2022, at which time he succumbed to his injuries. The Onslow County Sheriff's Office presented their findings to the Onslow County District Attorney's Office on January 7th, 2022. At that time, Onslow County District Attorney Ernie Lee reached out to District Attorney Ben David of the New Hanover and Pender County District Attorney's offices for outside assistance. On January 8, 2022, District Attorney Lee and District Attorney David spoke about the incident, and District Attorney David agreed to evaluate whether criminal activity took place and to prosecute the matter if charges should arise. Pursuant to North Carolina General Statute 7A-64, a district attorney may apply to the director of the Administrative Office of the Courts to temporarily assign an outside prosecutor to assist in the prosecution of a case if there is an actual or apparent conflict in handling a case. Such conflict can include where the district routinely works with a person who is the subject of a criminal investigation. Clukey is a veteran detective of the Jacksonville Police Department and is the lead investigator on several pending felony and homicide cases with the Onslow County District Attorney's Office. District Attorney Lee made the formal request for assistance to the Administrative Office of the Courts. Assistant Director David Hoke on Monday, January 10th, and the request for temporary assignment to District Attorney David was made that same day. The Onslow County Sheriff's Office delivered the findings of their ongoing investigation of this incident to District Attorney David on January 10th and January 12th, 2022. District Attorney David convened a critical case review of this incident on January 13th, 2022, giving senior prosecutors from his office the opportunity to review the facts of the case and decide if criminal charges were appropriate in this matter. Follow-up investigation stemming from the critical case review was conducted by the Onslow County Sheriff's Office and delivered to District Attorney David on January 19th, 2023.
In addition to the factual summary that Ms. Waller just read to you, there are also pictures of the service weapon that was used in this case, a Glock 9, as well as the 2 airsoft pistols that were the subject of this investigation. So now I'm going to summarize our legal conclusions that stem from that outside investigation. When considering the law, my prosecutors and I are guided by the words of the North Carolina pattern jury instructions, which judges use in trial to explain the law to the jurors who decide a case. Quote, "A killing is accidental if it's unintentional, occurs during the course of lawful conduct, and does not involve culpable negligence," end quote. The burden, as always, is on the state to prove that a killing is either intentional, occurred in the course of unlawful conduct, or involved culpable negligence before any criminal charges can be brought. So my senior prosecutors and I carefully considered first whether there was any evidence of this killing being intentional, second, the lawfulness or unlawfulness of the surrounding course of conduct, and third, the presence or absence of what is termed culpable negligence or criminal negligence in the law. First, there is no evidence that John Clukey intended the death or injury of Alexander Clukey. This possibility was, again, the subject of thorough investigation to be as certain as possible as to what happened. However, no substantiated evidence of any domestic abuse or threats of abuse or any homicidal ideation or planning have been discovered. Everything about this incident shows a father who did not intend for this to happen. But of course, saying that the killing was not meant to have happened does not end our inquiry. It is a very different set of circumstances. A father, for instance, who knowingly drives recklessly and greatly excess of the speed limit under dangerous road conditions and who crashes his vehicle can and should be held criminally liable if the child who is a passenger is killed, even if that death was not meant to have happened. That, of course, is because a killing cannot be considered accidental if it occurs in the course of otherwise unlawful conduct, such as, in this case, reckless driving. However, there is no evidence that the killing occurred during the course of unlawful conduct. It is not unlawful to participate in a consensual airsoft game with one's child. Now, it is a crime, specifically a Class A1 misdemeanor, to knowingly point an actual firearm at someone. That's called assault by pointing a weapon. And that includes, and I'm quoting from the North Carolina General Statute on assault by pointing a gun, either in fun or otherwise, whether such a gun or pistol is loaded or not loaded, is an A1 misdemeanor. But an airsoft gun is not a firearm, nor is it a deadly weapon falling under the terms of that statute. So there have been many instances in which individuals have been charged criminally for a shooting death in which they pointed what they knew to be a firearm at someone but mistakenly believed that firearm was unloaded. Again, and this is a key finding of the investigation which our analysis returned to again and again, the totality of the evidence shows that John Clukey mistakenly believed he was pointing a toy and not a firearm at Andrew Clukey. So even if the killing was unintentional, and even if the killing was in the course of otherwise lawful conduct, the killing would not be deemed accidental if it were done with a mindset of culpable negligence. That's also again known as criminal negligence. The two terms are synonymous. An action taken with culpable negligence, proximately resulting in another's death, qualifies as what's called involuntary manslaughter. Again, we turn to the North Carolina pattern jury instructions to define culpable negligence. And I'm going to quote those pattern jury instructions to you now. Culpable negligence is more than mere negligence. An act is culpably negligent if, judged by reasonable foresight, it was done with such gross recklessness or carelessness as amounts to a heedless indifference to the rights and safeties of others. As appellate courts in our state have consistently held, quote, as it relates to involuntary manslaughter, intent's not the issue. The crux of the crime is whether an accused unintentionally killed his victim by wanton, reckless, or culpable use of a firearm or other deadly weapon. Now, a preventable death caused when someone exercises less care than they should does not by itself constitute involuntary manslaughter. Clukey, to be clear, should have been more careful than to have played an airsoft game while wearing a holster with a real firearm. There's no dispute about that. But the state of mind required to make the conduct a crime, and specifically the crime of involuntary manslaughter, is, quote, conscious, heedless indifference to the safety of another, end quote. This is qualitatively different than simply being less careful than one ought to be. Criminal negligence is instead on a spectrum that includes the state of mind called implied malice, when a person knows that what they're doing is likely to bring about serious injury to another and yet does it anyway, thereby making them liable for even up to second-degree murder if the death is reasonably foreseeable. Courts have held that criminal negligence and implied malice, these two states of mind that involve conscious, antisocial disregard of known risks and safety to others, differ only in degree and are neither to be confused with simple negligence. So two recent involuntary manslaughter cases in North Carolina illustrate this sort of heedless indifference to the rights or safety of others that stands in marked contrast to mere negligence or carelessness, as that term is used civilly. In one case that occurred last year, State versus Metcalf, the defendant, when fleeing her burning home, failed to take the 3-year-old nephew of her boyfriend with her, knowing that the 3-year-old was inside, and several times told others, including first responders on the scene, that there was no one inside. She later admitted that she could have removed the child from the burning home when she exited and was convicted of involuntary manslaughter under that culpable negligence standard. The same for a case from approximately a decade ago, State versus Fisher, a North Carolina Supreme Court case in 2013, where the defendant became angry at the victim during the defendant's party and kicked or stomped his face, leaving the victim semi-conscious. The defendant was irritated that he had to take the victim to meet the victim's parents at a church. Instead of taking the victim to that church, he drove him to an isolated parking area and beat him again. The defendant abandoned the victim outside, knowing that the temperature was sinking into 20-degree range and that the victim had been beaten, was intoxicated, and not wearing a shirt. The defendant realized his actions put the victim in jeopardy, and even after being directly informed by the victim's father that the young man was still missing and that officers were concerned about him, the defendant lied about where he had last seen the victim. This hindered the efforts to find and obtain medical assistance of the victim, who later perished. That again was considered to be heedless indifference to the rights and safety of others, tantamount to culpable negligence, making him responsible for involuntary manslaughter. Now, set aside these two examples that appellate courts in our state have upheld as meeting the definition of culpable negligence, it is clear that John Clukey's actions do not display the sort of heedless indifference to another's safety that would make his actions a crime. This is not a case of Clukey mistakenly reaching for his service weapon while in the performance of his duties. All of us are aware of the most recent case from December of last year involving Officer Potter in Minneapolis shooting and killing Dante Wright in a traffic stop when she mistakenly reached for her service weapon when she thought she was pulling her taser, and was convicted of first-degree murder. This was not in the course of conduct. This was off-duty conduct. And this is an accidental shooting that occurred while a father and son were engaged in horseplay. As such, this is much more similar to the case from Florida back in 1992, some 30 years ago. State versus JCD, in that case a juvenile that the court referred to as JA, accidentally engaged the trigger of a gun he thought was unloaded. He was charged and convicted of involuntary manslaughter under a theory of culpable negligence. In reversing the conviction, the appellate courts cited numerous examples of cases that, quote, may be the product of simple or gross negligence by the accused, but cannot rise to the level of culpable negligence so as to constitute criminal manslaughter, end quote. In dismissing the case, the court held there that, quote, the totality of the evidence in this case establishes that J.A. accidentally shot and killed his friend while carelessly handling a loaded rifle in the deceased's presence. J.A. was not engaged in an argument or physical combat with the deceased or anyone else. There was not the slightest bit of animosity between J.A. and the deceased, as indeed the two were friends. And J.A. was extremely remorseful after the incident. Moreover, J.A. was not under the influence of drugs or any alcohol. Now, in this case, it is debatable whether an involuntary manslaughter charge against John Clukey would survive a motion to dismiss. I have listed 3 different North Carolina cases that all had someone convicted of involuntary manslaughter under that culpable negligence standard, only to be dismissed later by a court of appeals or the Supreme Court, meaning it should have never reached the jury. So we can debate whether or not a charge would ever reach that jury box for the community to hear. But what is beyond any serious discussion is that it would be virtually impossible to secure a unanimous verdict of guilt against John Clukey in the death of his son should this case proceed to trial. My office has long been guided by the standard that we do not proceed to trial on cases where there's not a realistic likelihood of conviction. There is no question that the death of Alexander Clukey is a tragedy. By any objective measure, this is one of the most heartbreaking losses imaginable. If we punish merely on the basis of emotion, many of us would want criminal sanctions to be swift and severe. Yet in this present instance, there is insufficient proof that John Clukey acted in a culpably negligent manner. Accidents do happen, and not every tragedy is a crime. After thoroughly reviewing the facts and analyzing the applicable law, I, together with my senior prosecutors, have determined that no one will face criminal charges in the death of Alexander Clukey. With that, I'll be glad to answer any of your questions.
Just Attorney David, I have a question. Just for point of reference, is there a specific location that we can be disclosed as far as where the actual shooting took place, the address of the home?
Yes. In terms of I believe we listed it. It was in just outside their residence in Beulahville, where they were, and it was actually between their home and an adjacent home in what is behind a cemetery area, right near their home, off to the right-hand side as you're facing it. This was out of view of any doorbell cameras and was out of view of any witnesses, as we detailed in the factual basis. But that is where first responders came within the 11 minutes of the call, and that is where this incident took place and the crime scene was processed.
Just to make sure that we're want to be as clear and precise as possible, what we're saying based off of the evidence that we've drawn from this and the investigation that's going on from your offices, this was not a culpably negligent, or this was determined as a culpably negligent act for him to have an actual firearm while he was playing with airsoft guns as well?
Yes. To be clear, many people can debate whether this was negligent to play with airsoft guns while also having a loaded weapon on your side. I think most people would say that it is. That's not the legal standard for criminal charges, specifically involuntary manslaughter. That degree of recklessness is known as criminal negligence or culpable negligence, and that's a different standard. I've tried to list several North Carolina cases and even cases from other states that applied that standard to the facts of those cases to determine whether or not, A, we believe that it could even survive a motion to dismiss, and B, if it did, whether we would have a likelihood of conviction at trial. In my view, and again, I take responsibility for this legal determination and no one else. I believe that the only appropriate thing here is to file no criminal charges against anyone for this case, and I stand by that decision. Yes?
Would you say there was any chance that he would have been able to tell the weight difference between the actual handgun?
Absolutely. In fact, that was the subject of our investigation. The guns were weighed. The service revolver, the Glock 9, and compared to the airsoft guns, they do weigh something differently. There's no question that factored into our analysis. And if you're wondering, it also factored into our analysis that John Clukey regularly trains with that firearm and has more training and experience than the average citizen. So that is certainly something that factored into our analysis as to whether or not criminal charges should be forthcoming in this case. And it's something that reasonable minds and people can disagree on. What I would respectfully ask you to consider is whether you can walk down the street right now and find 12 people to unanimously agree on it. And I await that answer. Next question. Again, we'll be glad to give you these press packets. I really appreciate the work that you all do. I think it's important that the community be able to visibly balance whenever something like this happens. Obviously, the public is the one who decides these kinds of cases in criminal courts where appropriate. And when they don't, they invest us with great responsibility. And because I've taken on the responsibility of handling this outside conflicts case, I believe that the appropriate thing is to be as transparent as possible about all the facts and law that went into that decision, and I take responsibility for that decision. I want to thank the more than half dozen senior prosecutors in my office who have worked tirelessly on this case over the last 10 days since we've received it, and I thank you for being here today. Good day.
Thank you.